Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields.
Afternoon, everyone, and welcome to Business Legal Lifecycle TV. Thank you for joining us. I'm Craig Mason. I have with me Jeremy Stretton.
How are you going, everyone? Hope you're having a great day.
Excellent. So we're moving into the month of May 2018, and we're moving on to the next phase in the Business Legal Lifecycle. Today's show is our longer form show that we do every Wednesday. So we're going into a bit of a deeper dive on a particular topic. At the moment, we're talking about bringing on employees. Jeremy, do you want to explain a bit more about this particular phase of the business legal lifecycle?
Absolutely. So for those watching us on the Facebook Live, YouTube or Periscope, I've just brought up a slide, just as a title slide. If you listen to the podcast and you want to see these videos, please feel free to log on to Facebook, type in Business Legal Lifecycle, and you'll find our videos saved there. So just moving on to the next slide is the 13 phases of the Business Legal Lifecycle. And you'll notice phase 4 has been highlighted, circled, and that's bringing on employees. Now, you'll notice too that this is at the top of the first, or just before the first dip in the Business Legal Lifecycle. And we thought it was probably a good idea just at this point, just to explain why that is. So we acknowledge that in all businesses, there's going to be good times and there's going to be bad times. And usually there'll be some sort of dip in your business when you bring on an employee. Now, that doesn't necessarily have to be a bad thing. It could be a dip in the time that you've got to work in your business. It could be a dip in the time that you've got to work on your business. It could be a dip in the profits because you're spending time training someone up. It could be a dip in many, many things. So we wanted to acknowledge the fact that there are good times and bad times in business. And that's why we put the dip into this part of the business legal lifecycle. You'll notice also that this is the first phase in the consolidation phases of the business legal lifecycle. So phases 1 through 3 are the startup phases. 4 through 6 are the consolidation phases. And the reason for this is that when you get here, when you're in phase 4 and you finish the first 3 phases, this is when you've actually started up your business, you've got all your structures right, you're getting some clients through the door, and now it's time to start bringing on some employees to help you run the business and to free up your time. That's why we put it at the beginning of consolidation. That's why it's where it is in the business legal life cycle. So the idea is for anyone who hasn't watched any of our previous videos, and I'd encourage you to go back and have a look at our previous videos or listen to our earlier podcast where we talk about the phases 1 through 3. The phase 1 is about conception, where you get the idea for the business. Phase 2 is startups. This is where you start your entities, where you start your leasing premises. Phase 3 is all about initial clients, so that's about engaging your clients properly and making sure that you've got the procedures and policies in place to properly be able to engage with your clients. And then once you've got all that in place, then it's time to bring on employees. It's really important that you have all of that in place first, otherwise you'll suffer what so many business owners suffer, and that's doing things too early and doing things without the proper procedures and policies in place. So this is a really important phase. We're really excited about this phase. We've got some really cool people lined up to give interviews this month. But today, as Craig said, is our education webinar. and Facebook Live and podcasts. So we're going to talk about a few different topics. We're going to talk about employees versus contractors. Craig's going to cover that. Then I'm going to talk about the different types of employees. Then Craig's going to talk about what you need for your staff. So what are some of the legal requirements for your staff? Then I'm going to talk about agreements, the difference between an employment agreement and a contractor's agreement and why you need to have them. Then Craig's going to talk about workplace policies and the importance of those. I'm then going to talk about restraints of trade. And you'll probably hear barbecue advice from people saying that they're not enforceable. That's not right. They are, and I'm going to tell you how they are enforceable. And then Craig's going to finish off by going through an overview of dismissal of employees. So that's an overview of today's show. We really encourage you to watch all this or listen to the whole thing because there's a lot of content. If you are listening, or even if you're watching it, we'll have the show notes up shortly and a workbook, which you'll find at businesslegallifecycle.com.au/086 because this is our 86th show. But without any further ado, I'll hand over to Craig to talk about employees versus contractors.
Excellent. All right. Thank you, Jeremy. So as Jeremy said, employees versus contractors. So this is a pretty important step that you need to go through before you bring on an employee or bring on a contractor. And there's distinct differences between the two. And if you get this part wrong and bring on someone as an employee when they're really a contractor and vice versa, then you can get into some problems. So you want to work out exactly, it depends on the sort of role that you need someone to be doing. But staff are generally classified as either employees or contractors. Where you have an employee, they work exclusively for you and your business. They normally don't provide their own tools, and they're generally, as part of their employment, not entitled to go and work somewhere else at the same time. Whereas a contractor works for themselves. They can have many different businesses that they work for. They provide their own tools, those sorts of things, and essentially, are a gun for hire and can go around working for very different types of businesses and bosses. So that's the main sort of difference. And you need to sit down when you're doing this to work out that what you're about to do is not going to be classed as an employee if you want them to be a contractor. So one of the main ones is the degree of control over how the work is performed. So if there's a high level of control, then normally that would be classified as an employee rather than as a contractor. Because as we know, an employee will work under the direction of someone else. They'll have to follow that. And there's an ongoing performance review and those sorts of things as part of being an employee. A contractor, on the other hand, can come and go as they please, provided what the role is, and they can essentially, the work that they're doing is their own, and they have control over that. Normally, an employee will have obviously a set hours of work that they're expected to be there, whereas a contractor doesn't necessarily have that, depending on the type of contract. An employee obviously has an ongoing expectation that they're going to be employed, provided they do everything correctly, of course, whereas an independent contractor doesn't have that. So it could just be a 2-month contract and then that's it. So there's no expectation of ongoing work when you're a contractor. With risk, and this is a pretty important one, an employee is not responsible personally normally for the work that they do. The employer is vicariously liable for the actions of the employee, whereas a contractor takes their own risk. They normally have their own insurance, those sorts of things. It's their responsibility to run a profit. It's obviously got nothing to do with you, and they're essentially their own business. One of the main ones that people come unstuck with is superannuation. In an employee situation, obviously there's superannuation that needs to be paid. Whereas with a contractor, if it's done correctly, they're supposed to be paying their own superannuation contributions. That's where you need to be careful, because if you do it incorrectly and classify them as a contractor when they're really an employee, you're not going to be paying the super. And then if something happens, there's going to be issues with why it wasn't paid if they're really an employee. Same goes with tax. So an employee, you'll be withholding the PAYG tax normally and sending that to the tax office, whereas with an independent contractor, again, they're responsible to pay their own tax. You pay them $100 and they're supposed to pay tax out of that. So that's one of the main ones as well with super and tax, where people definitely come unstuck, and that's where the classification.
Craig, can I just interrupt there? Just say for any of our international viewers or listeners, superannuation is like 401ks in the States and pension plans in the UK. So that's the same kind of thing. Just to be clear about what we're talking about.
Yeah, absolutely. So yeah, and same with tax. Obviously, there'll be different tax rules, different jurisdictions, but generally, when we're talking about this is the ramifications. One of the final ones is tools and equipment. I touched on that. Normally an employee, comes to work and all the tools and everything is there, depending on the industry, of course. And they might have an allowance to buy particular tools, whereas a contractor brings their own toolbox and whatever else into the place and does their own thing. So they're the sorts of distinctions, and you need to be careful as to how you do this. Because as I said, particularly if you classify someone as a contractor when they're an employee, there's all sorts of penalties and interest and things like that might need to be paid on the tax and the superannuation and those sorts of things. In Australia, at least, there's a good tool about how to determine who an employee or an independent contractor is. So I'd invite everyone, if they're not sure, to run through that tool. And again, as I said, it's an important step to get right. So this is where you need to be seeking advice before you go too far down the garden path. You want to make sure you get the right advice about who and how you should be classifying potentially your first employee or independent contractor into your business. So it's a pretty exciting time, but get this part right, and then the rest of it should be smooth sailing, hopefully. So yeah, that's employees versus contractors. Jeremy, did you want to touch on the next slide?
I'll move on to types of employees. Just on that too, we'll link a copy of that tool onto the show notes if people are interested to find out more of that. All right, so types of employees. So there are different types of employees, and it's really important to understand the distinction because there's about 5-6 types of employees, probably 5 most common ones. And you need to understand what the different employees are because they have different rights and obligations. Now, once again, we're talking about Australian law. The law is very similar in other countries, but we are cognizant of the fact that we do have viewers from other and listeners from other jurisdictions. So we're giving you the Australian context. In the future, we'll give you some of the other countries' context as well. We're working on that. But the main types of employees in Australia are full-time employees, part-time employees, casual employees, fixed-term employees, daily hire employees, and then weekly hire and outworker employees. And I'll just go through briefly what each of them are. But it's really important that if you're not sure, basically if you're not sure whether someone is full-time, part-time, casual, or any of the others, that you get some advice. It doesn't have to be a lawyer, it can be an employment consultant. We're going to be interviewing some pretty cool employment consultants over this month. If you don't know any, but I'd encourage you to make sure you get advice if you're not sure. So a full-time employee is a person that works full-time in your business, which is usually around 38 hours per week. The actual hours the employee will need to work will be determined by the employer and employee by agreement. And there'll be other conditions that are set as a minimum by, in Australia, an award or a registered agreement. It is possible for a full-time employee to become a part-time or casual employee, but that can be very difficult because essentially you're taking away their rights. Because as a full-time employee, they've got a lot of rights. A part-time employee basically is someone who has those same rights but works 38 hours a week. Or sorry, less than 38 hours a week. That's really important because you need to be sure that whether or not they're a part-time employee. And a lot of people get wrong the distinction between part-time employee and a casual employee. So a part-time employee has guaranteed work hours, whereas a casual employee has no guaranteed hours of work. Every week they may have different hours of work, and they may have different expectations of when they need to be there. So the classic example is in a restaurant or a nightclub or even a retail shop where a casual employee is set a roster every week. Now, if that same roster is set every week, and they have the same hours every week, then arguably they could be a part-time employee. And there's a really grey area here because, and the distinction is that a part-time employee, like a full-time employee, you have to take out all their tax and super. Where a casual employee, you don't have to, sorry, not that tax and super. You still have to take out the tax and super, but you have to, they're entitled to sick leave and holiday leave. part-time employees are entitled to sick leave and holiday leave paid. Casual employees aren't. That's factored into their wage. So you need to be aware of that because you're actually paying them a higher rate to give compensation for the fact that they're not entitled to sick leave, carers leave, and holiday leave. So a casual employee, you need to be really careful. And I know lots of businesses where they've really got part-time employees, but they're calling them casual employees. And you have to be really careful because after 12 months, that casual employee can ask to become a part-time employee. Now, you don't have to give that, but you need to be really, really careful on those requirements. The other thing to remember too is that a casual employee is not usually entitled to maternity leave or paternity leave, whereas a full-time or part-time is entitled to that type of leave. Part-time, obviously, prorated to their the amount of days that they work in the business. So that's a quick overview and they're the three main types of employees: full-time, part-time, and casual. You'll see that there's lots of little moving parts and there's lots of things that can be different. So make sure that you get advice if you're unsure if your employees are part-time or casual, especially because that's somewhere where people fall down a lot. A fixed-term employee, as the name suggests, a fixed-term employee is one that enters into a contract for a fixed amount of time. So, for example, they might enter into a contract for 3 months, and that ends after 3 months. These are different to permanent employees, as the fixed-term employees are not guaranteed work on an ongoing basis after the relationship is ended. They can, but if if you've got someone on a 3-month fixed-term contract and that ends, then you can no longer require their services after that. Daily and weekly hire. In the building, construction, and plumbing industries, employees can be hired on a daily or weekly hire basis. The employee must be told before that they become employed that they've been hired on this basis, because you don't want them to think that they're another category of employee. Here, you're able to terminate them on 1 day's notice. And the reason for that is clear, that in that industry, often you need workers quickly, and you want to have the ability to be able to bring them on quickly and then remove them quickly if you need to. That's something that you need to get a lot of advice on to make sure that you do it right, because there can be, there's a very grey line, I should say, between full-time, part-time, casual, and daily and weekly hire. So you've got to make sure that your agreement's really sound on that. And the last one are outworkers. And these are generally employees, but they can also be contractors who would perform work from their home or at a place that is not usually their business premises. They've usually got minimum employment standards, and they need to be paid the same rates as other full-time and part-time employees. And that will depend on the award. Some awards actually say to pay outworkers less. So you need to be really careful on what the award says. So as I said, there's many different types of employees. There's many different types of rights that go with each type of employee. So you need to be really careful that you're getting the right type of employee for your business. Craig, do you want to move on to the next part?
Yeah, absolutely. So the next slide is what you need for the staff. So there's a number of legal requirements that employers have to meet for their employees. These can change from time to time, but we're just going to go through some of the main ones that sort of universally always part of it, whether you're in Australia or anywhere else. So one of the main ones is the award that's in existence for the particular industry. So most industries will have an award, and you've got to work out that what award applies to your employees. So that's the first thing you need to do. The award sets out minimum standards of the employment. You need to read the award, make sure you're familiar with it all. It'll have in there the minimum wages and those sorts of things, which obviously is important because you want to be paying them at least the minimum wage, and it'll have various other conditions in there as part of the award. So the first thing you need to do is have a think about what the award is. If you're not sure, ask some questions with either your advisors or give the relevant government body a call so they can help you out. The next one, and it sort of goes with the award, and again, most people as employees expect this, is the payment of wages. So obviously you need to make those payments. You can decide prior to bringing on the employee as to how often those payments are going to be, whether they're weekly, fortnightly, twice a month, monthly, whatever it might be. And that will be part of your agreement with your employee as to when they're going to be paid. But obviously, whatever it is, you need to stick to that, make sure the wages are paid. As part of that, you also should give pay slips or have pay slips available and give those to the employees after the payment of wages, which shows them how much they were paid, their sick leave, annual leave, superannuation, those sorts of things go on the pay slip. One of the other things that you may need to do as an employer is reimburse the employee for any work-related expenses that they may incur during their employment, and you should reimburse those as quickly as you can. Another sort of self-explanatory one, as an employer, you need to ensure that they have a safe work environment, so that your employees are safe while they're at work. Kind of goes hand in hand. But if you're in a particular industry where it's high risk, or there's various things that can fall down and whatever else, then you need to speak to your consultants, make sure it's all set up properly, and then you can providing a safe working environment. The next one, and this is a big one, is the payment of tax. So as an employer, you must collect or withhold an estimated amount for the employee's tax, and then normally you would pay that to the Australian Tax Office or whatever other body it might be in a different country, but most countries have to pay tax, unfortunately. So that gets paid in Australia, depending on how you set up, on a monthly basis. You can pay it earlier if you want, or on a quarterly basis. So you need to make sure that you're withholding that when you pay the wage. Same goes with superannuation. So in Australia, that's over and above your wage at 9.5%, and that goes again to the particular super funds, and you need to make sure that you're paying that as well. And you can pay that again on a whatever basis you want, but quarterly or monthly is the normal for that, for payment of superannuation. We just got to make sure you're doing it, and you need to calculate that as an employer. So you need to double check the figures and make sure you're calculating it correctly, because you don't want to underpay it. The same goes with goods and services tax. So if you're using contractors, that is, and they collect GST, then you need to make sure you pay the extra amount, so you're complying with the GST requirements. Again, that's an Australian requirement. The last thing, as part of having an employee, you need to ensure that you're complying with the national employment standards here in Australia. So there's 10 minimum employment standards, and these are the maximum weekly hours, which is you got to make sure that you're complying with that. You've got to, if there's any requests for any flexible working arrangements, you need to consider that if appropriate and provide those. Jeremy touched on the leave requirements, so parental leave, annual leave, carers leave, compassionate leave, long service leave, obviously public holidays, depending on the industry again. You need to make sure you're aware of all those and allowing your employees to do that. And if it ever gets to that, we'll touch on that a little later in today's show about notice of termination, redundancy, those sorts of things. Pretty big. You got to make sure you comply with all of that. And the last one that we wanted to touch on was insurance for your workers. So you need to make sure you're complying with the local laws and states legislation about insurance for your employees. Generally, that's called work cover insurance or something similar to that, and you pay the premium based on the amount that you pay your staff. So that's a requirement to have work cover. If someone gets injured, then they might be able to go through work cover. So there's a lot to what you need for staff, and obviously you want to try to get all this in place at the beginning. So as you bring on more employees, it's a straightforward process. You've got it all. You're aware of everything. You've got the right advice, and you're not going to come unstuck with any issues down the track. So yeah, they're the what you need for your staff. Jeremy, do you want to move on to agreements?
Yeah, absolutely. So I wanted to start off by just addressing a misconception that's out there. And that's that you'll often hear people say something like an employment agreement is not worth the paper it's written on. And that's rubbish. It should be that a poorly written employment agreement is not worth the paper it's written on. Because a properly written and considered employment agreement that actually is drafted by someone who knows what they're talking about can be very, very good and can actually really help define the relationship and set the boundaries and put the basically resolve any disputes in a really timely manner. So remember that in any contract, whether or not you're getting your lawyer to draft it, you're doing it yourself, you're copying someone else's, an employment agreement, like any other type of agreement, is designed to basically be a backstop. It doesn't need to address everything that goes on day to day in the business or everything that goes on between the parties. It's there in case there's a dispute to set the minimum standards of what needs to happen in the relationship. So I'm going to go through some of the important things that need to be in there. But I did say before, whether you borrowed it from someone else, I strongly recommend against that. I know that businesses, especially early on, you're bootstrapping, you're trying to get some cash together. But putting a good employment agreement in place early will save you in the long run later on. It's like when we talked about initial clients and putting together a proper agreement with your clients. That's really important to have in place so that you protect yourself going forward. And the same is right about employees. When you bring on your first employee, and as Craig said, it's usually an exciting time. You're bringing someone in. You often skip these things because you don't have enough time, and then you're scrambling to fix it later on. So yes, it costs us a bit of money, but it's money well invested, and it is worth the paper it's written on if you do it right. So the kind of things that are going to an employment agreement, and I'll address contractors agreements in a little bit, is the term. So how long is the agreement going to go for? If it's a fixed period or whether it's an ongoing employee-employer relationship. If there's an award, you need to address that award, state what the award is, whether the award applies, or whether or not you're actually exempt from that because the conditions that you're giving the employee are actually over and above what the award says. The titles and duties of the employee. Often this is kept far too general. You need to be specific about what you require your employees to do. So a good place to start is a job description to go into the agreement, and then make sure that it can be modified when agreed by the parties so that it's really clear what the person's actually doing within the business. Because once you define what they're actually doing, they have certainty and you have certainty, and you can keep them to account. Craig will address workplace policies in the next section, but you need to incorporate compliance with workplace policies for each staff member so that it's actually an expectation that they will comply with those workplace policies on a daily basis. Hours of work, you need to set out what the minimum hours of work are so that there's clarity over those. Usually you'll set the hours, so Monday to Friday, 8:30 to 5 is a common one, with an hour lunch break and another break at another point during the day. Warranty. So warranty is one of those legal terms. It's a promise that someone makes, which if untrue means the other party can take action against them. So the employee should make a number of warranties about their financial position, disclosure of injury, those kind of things in the employment agreement, just to make sure that if they haven't told you the truth, that you've got some action that you can take against them. Usually you'll have a probationary period of 3 months. So you should talk about that and put the rights and obligations for that probationary period in your agreement. As Craig said before, payment of wages, very important. So you need to include that so that the employee knows what they're getting paid. Bonuses, if you're going to have a bonus structure, what does that bonus structure look like? How's it calculated? Put that down in writing so that it can be really clear. If you have it in a policy, refer to the policy so that there's no disagreement as to what is agreed, because it is amazing how people hear what they want to hear when you have a conversation with them. And if you just put it in writing, you'll solve all of those problems that happen from a he said, she said argument. There's also the minimum standards that you as the employer have to meet. So you've got to pay superannuation, as Craig said before, expenses, provide leave. These all should be set out in the agreement so there can be no dispute as to what you're actually doing. Protection of employers' interests. I'm going to talk about restraints of trade in a little bit, but confidentiality, restraints of trade, all these things need to be there to protect your legitimate business interests. And I'll talk about those in a bit more detail after Craig's talked about workplace policies. Termination. The ability to terminate the employment agreement on certain grounds is very important. You need to have the minimum standards, and then you need to be able to provide that the employee's employment can be terminated if they do not meet those standards. That's something that's often missed, and so you need to be really careful to make sure that you cover off on those. So they're the minimum things that go into an employment contract. A contractor's agreement, and as Craig talked about right at the beginning, a contractor is different to an employee because they have no set time of work. So the actual terms of the contractors agreement are different because they deal with different things. So the first one is the scope of the work. So what is the contractor actually doing in your business? What are they employed to do? That's really important. Assignment, what's their ability to assign the work to someone else? So if you give them, 30 hours of work during the week, they don't have time to do all those 30 hours, can they do part of it and then give the other part to someone else? What are the rules around that? Payment terms, very important. Setting out, how you're to pay them. Usually it's provision of some sort of tax invoice for showing the hours that they've worked, and then a certain time frame for payment. Access, so as a contractor and not being an employee, a contractor doesn't necessarily have a right to access your premises or the premises where you're doing work. So you need to grant them access so that they can actually access the site that you're doing work on, or the business premises. Provision of tools and equipment. As Craig mentioned earlier, this is one of the factors that goes to determining whether someone's an employee or a contractor. So you need to talk about that. Are they going to use their own tools? Obviously, as a contractor, it'd be better if they do. And if you're providing tools, well, what are the terms of that provision? Liability and requirement to be insured. So as Craig said earlier, if you're a contractor, you need to have insurance. So you need to talk about that and what are the minimum standards of insurance that you want your contractor to have. Site rules and possessions. So you need to set out clearly what the site rules are. And then there'll be some independent or industry-specific clauses. So this is where you need to be really careful. Say in the building industry, you need to consider contractors, defects liability periods, retentions, and provision of final certificates. You need to be really careful if you're employing contractors that if you're getting them to do certain works, and then those works form part of a larger contract that you have with the person that you're doing the work for, you need to make sure that the contractor has some sort of liability going back to those contractors so that you can make sure that they can rectify the works. So the terms of these contracts are really important to make sure that you define the relationship. As I said before, they're not there to govern the day-to-day workings of the relationship. They're there to govern the what happens if something goes wrong. So make sure that you get them done right. Make sure that you don't just use some cookie cutter agreement that you found from some friend or colleague, that you actually get them properly drafted because they'll be worth their weight in gold. Craig, do you want to move on to workplace policies?
Yeah, absolutely. So as Jeremy said, workplace policies sort of tie in with the employment agreement. As part of a good employment agreement, it'll have in there that the employee agrees to comply with the workplace policies. So workplace policies are a set of minimum expectations and requirements that apply to all of your staff. Unfortunately, they're often missed as part of bringing on an employee, but we consider them to be vitally important to have the policies in place at the beginning. They're there as you bring on other employees. You don't need to worry about it again. So the types of requirements that are normally included in employment policies are a dress code policy. Obviously it's common sense for most industries, but if you don't have a policy of a minimum dress standard, then there's no clarity to an employee as to what they can wear. So you should have a minimum set of requirements for your general dress code. And if you have sort of, casual days, then, something about what can be worn on a casual day. So you maintain, the level that you want in terms of a dress code within your business. If you just leave it loose, then, you're going to have loose dress codes as well. So make sure you've got a policy there. So one of the big ones as well that you see a lot of in employment policies, and again, this common sense, but if you don't have the policy in there, then there's obviously a grey area, is drug and alcohol policy. As I said, pretty obvious to have rules regarding this, but where it becomes an issue potentially is, drinks at lunchtime or whatever it might be. So you need to have a policy in place about that. It's obviously zero tolerance in terms of, drug and alcohol or being affected by those during work hours. But if there is a lunchtime thing, then you need to have a policy that governs that. We're obviously only talking about alcohol during a staff function or whatever it might be, but you want to have a policy about what can happen and permission and those sorts of things. Another one is workplace harassment and bullying. Obviously, the policy is zero tolerance for these sorts of things, but you need to outline, sexual harassment, anything on race, religious, those sorts of things is not allowed. And there should also be, as part of that, the procedure for a victim to make the complaint and who's dealing with that and those sorts of things, to make sure that there's a consistent process that can be followed by an employee if anything like that ever does happen. Same goes with just a general grievance policy. So if an employee's got an issue with something, whatever it might be, they need to know where they have to go to speak to someone about that. So whoever that might be, you need to have a recommended procedure in place so they can follow that if something again happens. Most of these are common sense, but if you don't have them in place, then employees don't know what to do. That's when people start complaining. I don't know what to do. Where am I supposed to go? Et cetera, et cetera. So you want to have a policy in place so they know what to follow. Another one that's becoming more and more prevalent is policy regarding email, internet, and social media. So as we know, email, internet, social media, those sorts of things, if it's used incorrectly, then it can have a negative impact on your business. So you obviously can't control what staff are doing, outside of work hours, on the weekend, on these sorts of platforms. But you just want to make sure that there's an expectation there and a minimum standard as to what your employees, are going to do on social media in particular, because you don't want clients to see them, doing whatever on the weekend or during work hours, or making comments about something. So you've got to make sure that you've got expectations in a policy regarding social media use in particular for your employees. And the last one we wanted to touch on, and this is depend on the industry, is vehicle and other equipment policy. So if your business uses vehicles and other equipment, then you need a policy in place about how they're to be used. If it's only for use for work, or they can use it for private use, whatever it might be, you need to have a minimum policy for the vehicles and other equipment that the employees can use as part of their employment. So they're the types of workplace policies that we consider as important for most businesses. And as I said, often missed, but something that's really important as part of your employment agreements. So yeah, that's workplace policies. Jeremy, you wanted to touch on restraint of trade.
Yeah, so restraints of trade are one of those things, once again, like the employment agreements, that people often think aren't enforceable. So let's start up by just debunking that myth straight away. Business owners often think they have a right, and that term right gets thrown around a lot, but it's not the correct term to use in Australia, because there are very few legal rights. If you're in the States listening to this, you'll know that you have the Bill of Rights. We don't have anything like that. We do not have particular rights. We have the ability to protect ourselves by having contracts in place. So people often think that restraints of trade aren't worth the paper they're written on, but they are if they're done to protect the legitimate business interests of the employer. Now, what are legitimate business interests of the employer? Well, that can be very different depending on the circumstances. For instance, if you're a real estate agent and you're in a street in, say, Redcliffe, and you have 10 other real estate agencies in the street, to say that one of your employees can't go and work for another real estate agency 5 kilometres away or 2 kilometres away is just not right. To say that they can't go and work for someone else in the street just is not protecting your legitimate business interests. If they start stealing clients, if they start stealing employees, that's different. That's breach of confidential information, or breach of trade secrets or your business's particular business interests. But restraints of trade are enforceable if they are legitimate protections of your business interests. So these are really important to make sure that you have them done right. Make sure that they're drafted correctly, and make sure that they're actually going to protect you. So the restraint of trade that's going to protect you the most is one that says that a former employee cannot steal your clients or contact your clients for a period of time. If you draft that properly, then that will be protected. If you say that, if you drafted an employment agreement that says that this employee can't go and work in the same industry in competition with you in Australia for a period of 10 years, it won't be enforceable. It simply won't be enforceable. Even if you said 10 kilometres for a period of 5 years, it wouldn't be enforceable because you've got to be able to legitimately protect your business interests. At the end of the day, you need to trust the fact that if you're hiring these people, that they're actually going to do the right thing by you. You know, Craig and I can talk from our own personal experience where we actually turn clients away, turn them away when we first started our business because we didn't want to breach our restraint of trade and we wanted to do the right thing by our employees. And we expect the same of our employees, and you should too. People should do the right thing. Now, I know that they won't always, so you need to have restraints of trade in place. You know, I'm not that ignorant to say that every employee is going to do the right thing, but you need to be able to have a legitimate restraint of trade that protects your business. This is where you need to talk to your lawyer or you need to talk to your employment consultant to make sure that it's drafted correctly. So I'm not going to go through and give all the circumstances because there's no way that in a podcast or a video recording that I can say this is the formula to write a perfect restraint of trade for your business. What I'm going to say is if you feel it necessary, that you think that you need to protect your business from your employees, go and get advice. Make sure that what you're doing is protecting your legitimate business interests. Just putting anything in place is not going to work, and you need to make sure that you get it drafted properly. So that's what I'm going to say about restraints of trade. Craig, do you want to talk about dismissal of employees?
Yep. Unfortunately, there's going to be times where an employee needs to exit the business, and there's certain procedures that you need to follow. And the whole point of what we've been talking about today with having agreements, having policies, and those sorts of things in place is that if an employee breaches those, then you've got grounds for dismissal, provided you follow the right process. So again, not something that you just rush into. You've got to seek the right advice and make sure you're following the correct procedure, because the last thing you want is an unfair dismissal claim or some other related claim against you from a disgruntled employee. So you want to make sure you follow the process and procedure as best you can. Obviously, you can't always eliminate an employee making a claim, but at least you reduce the risk of it being successful or reducing the risk of how much the damages might be. So make sure you're getting the right advice. In terms of terminating employments, you obviously got termination and you've got sometimes redundancy as well. So redundancy is where, the job no longer exists, that you're not needed. And you've got to make sure that you follow that process properly. And there's all sorts of requirements under redundancy that you need to follow in terms of the payments and those sorts of things. So again, don't rush into that. Make sure you've got the right type of advice and you're not just using redundancy just because it sounds great and you think it's a good reason to dismiss an employee. You need to make sure it's actually a valid redundancy, because again, if it's not, you could have an unfair dismissal claim on your hands. The other one, of course, is termination. And normally termination is under three categories. One is inappropriate behaviour. The other is fraud or theft. And the last one, which is probably the more common one, is the actual performance of the employee. So inappropriate behaviour, again, of course, that comes back to your policies. If you don't have a policy about it, the particular behaviour, then you're obviously going to struggle to get up to that level of being able to terminate someone for inappropriate behaviour. So you want to make sure you've got your policies, which sets out the expectations. So if someone doesn't comply with that, then provided you follow the process, you could have grounds to terminate them on that basis. So it comes into sexual harassment, bullying, those sorts of things is normally in this sort of category. Again, you want to have a process where there's an interview process between the victim and the perpetrator and those sorts of things, and follow your process regarding that. The other one is fraud or theft. Seems pretty self-explanatory. Obviously we're talking about potential criminal charges being laid against an employee here. So this is probably the most serious of the three, or probably definitely the most serious of the three, I should say. So if you're going to allege fraud or theft, obviously, again, you want to make sure that's actually occurred. You want to follow the process. If the police are involved, those sorts of things, you don't want to, stuff up the police investigation either. So make sure you're following a a process and procedure and getting the right advice. Normally the person's got to be afforded an opportunity to, give their side of the story, offer them a support person, those sorts of things in that meeting. Again, the whole point of having a process in place is that you can easily just follow it, and there's no grey areas. You know exactly what you're doing. When you get an employee, you think they're going to be there for 15 years, which hopefully all of them are, but sometimes it doesn't work out that way. But if you've got a process in place that you can fall back to, then you know that you're in the best possible position. If you do need to terminate someone, you can follow that process. The last one that I wanted to touch on was performance. So obviously this is the more difficult one for termination because you're saying that the employee's performance is poor or not up to the standards. Again, you want to have a process in place that it's not just you haven't been doing it correctly, you're dismissed. You've got to have reviews and those sorts of things built in, giving warnings, those sorts of things. Make sure you're following the process. You want them to improve if they can, so you want to have that built into the process with performance reviews and those sorts of things. Because as I said, you want the employee to be there, like coming into work, and kicking goals for your business. So that's dismissal of employees. The three main ones, obviously, if you get to that point, not a great spot, but if you've got the policies and processes in place, then they'll guide you through it. And again, seek the advice of your advisors at this stage, because you don't want to be doing something incorrectly here, because you'll get a potential claim. So I think that's it for us, Jeremy. Did you want to touch on anything else, or are we?
No, I think that's everything. I think we've given a lot of content today, Craig. I think people, listening or watching this, there is a lot there. Thank you for watching and listening. As I said earlier, there are show notes and there is a workbook for today's episode. So please, if you're watching this on Facebook, I've posted the link to the workbook underneath in the comments section. The show notes we'll be sharing shortly on businesslegallifecycle.com.au/086. If you're watching the replay of this, it's probably already up. So please go and have a look at that. There, as I said, there is a lot of detail. We did cover off a lot today. Moving forward, Fast Fix Mondays are going to be going a little bit more in depth into these topics and the interviews as well. We're going to be talking to consultants who do this stuff every day. So you're going to get some practicals on what to actually do in certain circumstances so that you can see what other people have done. So once again, thank you for listening. Please share this Facebook podcast wherever you're getting it. Like it. Like our page. Share the content around. Make sure that we get more reach the more that you share this stuff around. And if you've got any questions, feel free to comment on wherever you're getting our content. We're happy to answer any questions and take it deeper offline if we need to. So, Craig, did you want to add anything before we finish?
I don't think so. Thank you, everyone, for joining us. We'll see you next time.
See you next time.